Socorro Clemente vs Republic. Topic: Revocation of donation, reconveyance, and recovery of possession. Facts: Clemente's siblings were the owners of a parcel of land donated, during their lifetime, in favor of the Republic, wherein in the deed of donation it provides that the parcel of land donated should be used solely or hospital site only and for no other else. In accordance with the deed of donation, the construction of a building for a hospital was started in the following year. However, for reasons unknown, the construction was never completed and only its foundation remains today. After 40 years of the said donation, herein petitioner inquired about the construction of the hospital but was later informed that DPWH no longer had a plan to construct a hospital at the site and that the DPWH had no budget for it. Thereafter, herein petitioner, as heir and successor in interest of Mayor Clemente, filed a complaint for revocation of donation, reconveyance, recovery of possession, alleging that the Republic failed to comply with the condition on the deed of donation. RTC dismissed the petition. CA dismissed the appeal on the ground of prematurity, as Socorro only have an inchoate right to the subject property. Issue 1. The action is barred by laches notwithstanding that the donation is onerous and instead placing it within the purview of the law on obligations and contracts. Ruling: the action is not premature and has not been barred by prescription or laches. An action for reconveyance based on a violation of a condition in a deed of donation should be instituted within 10 years from the time of such violation. Moreover, an action to revoke a donation based on non-compliance of the condition prescribes after 4 years from such non-compliance. Thus, to be able to determine whether the action has prescribed the time of non-compliance must first be determined. It is therefore imperative to determine the period within which the donee has to comply with the condition to construct a government hospital and use the site solely as a hospital site, because it is only after such time that it can be determined with certainty that there was a failure to comply with the condition. However, the deed of donation does not fix a period within which the said hospital must be built. Hence, it is within the ambit of the court to have it fixed. Article 1197 provides, if the obligation does not fix a period, from its nature and the circumstances it can be inferred that the period was intended, the courts may fix the duration thereof. Thus, when the obligation does not fix a period but from its nature and circumstances it can be inferred that a period was intended, the general rule provided under Art. 1197 applies. This general rule, however, cannot be applied considering the different set of circumstances existing in the instant case. More than a reasonable period of 50 years has already been allowed petitioner to avail of the opportunity to comply with the condition, even if it be burdensome, to make the donation in its favor forever valid. But, unfortunately, it failed to do so. Hence, there is no more need to fix the duration of a term of the obligation when such procedure would be a mere technicality and formality and would serve no purpose than to delay or lead to an unnecessary and expensive multiplication of suits. Therefore, because of the failure of the deed of donation to specify the period within which to comply with the condition, there can be no delay in asserting the right against respondent. In contrast, respondent is guilty of unreasonable delay and neglect in complying with its obligation to construct a government hospital and to use the subject property as a hospital site. The revocation of the donation and the reconveyance and recovery of possession in favor of the donors is therefore necessary and proper.